Welcome to this channel. In this video, we will learn a new Latin word, Pacta Sunt Servanda. Hope you will like this video. It is a principle in law. Please like, share and subscribe this channel. And don't forget to share your views in the comment section. Please check the description box for more videos. It is a Latin origin. It is the oldest principle of the international law. It is applicable in both civil and international law. Let us now understand each Latin words in English. Pacta means agreements. Sunt means they are. Servanda means to be saved. So it means agreement must be kept. The concept is the very principle which can be traced in the religious text as Al-Quran, where it runs as be truthful to the obligations you undertake. The very concept was introduced in the trade and commerce in the Middle East. Thereafter, we find in the canon law during the 13th century, in the writings of Henry of Segiusio, better known as Hostiensis, which was published in the 16th century. Later, the concept was developed by the Dutch jurist Hugo Grotius in the 17th century. In the very principle, Professor Hans Weber stated, few rules for ordering the society have such a deep moral and religious influence. We can say the Latin phrase as a principle through which treaty-based relation between the independent states are maintained. This principle is based on the principle of good faith. Hence, the parties to the treaty must fulfill their obligations. As the concept of this very principle is not new either to the domestic or the international community. So for the treaties between the different nations, either bilateral or multilateral, either party must follow, maintain and abide the provisions of the treaties. In short, treaties shall be complied with. The impact of this concept of the principle in the international sphere found in many documents such as Declaration of London 1871, Covenant of the League of Nations and the Charter of the UN. But the principle directly found in the Article 26 of the Vienna Convention on the Law of Treaties 1969 runs as every treaty in force is binding upon the parties to it and must be performed by them in good faith. Hirsch Lauterpacht, in the case of Norwegian, observed unquestionably the obligation to act in accordance with good faith being a general principle of law. In reference to the international arena, we can refer the case of Australia versus France. In the domestic arena, the Indian courts used the principle in their pronouncement. 1. Srimati Gitamma versus the Chief Secretary, Karnataka High Court, 2022. 2. Vidya versus the Life Insurance Corporation of India, 2004, Punjab and Haryana High Court. 3. Central Brokers versus N.K. Murthy and others, Madras High Court, 1953. 4. Magan Bhai, Ishwar Bhai Patel, etc. versus Union of India and another, Supreme Court, 1969.